You sued your doctor for medical malpractice, and now in answering the allegations to your lawsuit, the defense turns around and says, hey, don't blame us for your injuries. You, the patient, caused your own injuries. You know what we say to that? Come join me for a moment as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Come join me on this walk through the neighborhood. It's a beautiful day today here in Great Neck, and I wanted to share this quick information with you. You know what we say to the defense in response to that? We say, prove it. That's right. We make them prove those allegations. If they are going to turn around in an affirmative defense and say, hey, don't blame us for your injuries. We didn't cause your injuries, no matter what we did. You, the patient, caused and contributed to your own injuries. We say, prove it. Now, why is that? Because anytime somebody brings a claim in court saying that someone was careless, causing significant harm and injury, now the person bringing that claim has to prove it. It's known as the burden of proof. So now you, as the injured patient, you are known as the plaintiff, the person bringing the lawsuit. And in that instance, you have the obligation to prove your case. How do you prove your case? Through testimony, through evidence, through sworn written testimony, through medical records, and there are many other ways to prove a case. But you should know something really important. When we go ahead and prove our case, we only have to show that we are slightly more likely right than wrong than what we are claiming is true. We don't have to have the jury sit there for days and weeks to make 100% certain that what we are claiming is true. Instead, we only have to be slightly more likely right than wrong than what we are claiming is true. In that instance, the jury would be well within their right to give us a verdict in our favor. Now, if the defense turns around and says, hey, wait a second, no matter what we did, we didn't cause or contribute to your injuries. In fact, Mr. Patient, you were the one who caused and contributed to your injuries. You didn't listen to what the doctor told you to do. You didn't do X, Y, and Z, and because of that, you are responsible for your own injuries. So now we turn around and say, prove it. And now they have to prove that part of the claim, that affirmative defense saying, hey, Mr. Patient, you caused your own injuries, the same way we have to prove our claim, that the doctor was careless and that his carelessness caused you harm and injury. Now, how do they do that? They do that with sworn testimony. They do that with various witnesses. They do it with various medical records. Just like us, they don't have to prove that claim with 100% certainty. They only have to show that they are slightly more likely right than wrong than what they are claiming is true. Now, what happens at the end of the trial when the jury has to evaluate whether or not you, the injured patient, are partially responsible or fully responsible for your own injuries? I'll tell you what happens. At the very end of your trial, the judge is going to ask the jury to assess percentages of liability. Now, what does that mean? It means the jury will have to decide what percentage you, the patient, caused and contributed to your own injuries. They will also determine what percentage of the doctor whom you have sued caused and contributed to your injuries. If it turns out that you didn't cause or contribute to your injuries, terrific. Now it's 100% on the doctor. If you are partially at fault, that means that any money that you are given by the jury to compensate you for your injuries will then be reduced by the amount that you are partially at fault. So let's say the jury decides to compensate you $1 million, and the jury also finds that you are 50% at fault for your injuries. Well, guess what? Then the maximum amount that you can recover is 50% of what the jury has given you, which in this case would be $500,000. What happens, though, if the jury determines that you, the injured patient, are 100% at fault for your injuries? Well, guess what? Then the jury will be told, do not give the patient anything, or if they do, you will be entitled to get absolutely zero. Why? Because in that instance, the jury will have determined that you, the injured patient, were fully responsible for causing your own harm and injuries. So why do I share this quick information with you? I share it with you to give you an insight into what really goes on in these medical malpractice cases here in New York. You know, I realize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.